I want you, every time you get a copyright question, to break it down into 5 separate parts. First, we need to look at subsistence. Where are the works and other subject matters, or which works and other subject matter are implicated in the exam question or the practical issue that you're facing, where copyright might actually subsist. So you need to know the difference, firstly, between Part 3 and Part 4 subject matter. And then you need to know the types of subject matter that's covered in each one of those parts. So for original works, it's literary, artistic, dramatic, and musical works. For the Part 4 subject matter, these are the production copyright, the broadcasting copyright, the published edition, the cinematography, the films, and the sound recordings, and so on. So you need to know the difference, obviously, between Part 3 and Part 4. Main difference, or the 2 main differences, is one, a requirement of originality in Part 3, and a stronger protection of the reproduction right in Part 3 works as opposed to Part 4, which only covers direct copying. And then you need to know the rules for ownership, both the default rules, the exceptions to the default rule, and obviously that ownership can be modified by contract. Infringement's a little bit more detailed. We need to know how an infringement is actually established, both a direct infringement, which is by doing one of the acts comprised in the copyright, usually by copying, reproducing, broadcasting, and so on and so on. You'll need to know all of those different acts that trigger infringement, and they differ for any given copyright work. Not for the category of work. So the acts that infringe a film are going to be different to the acts that infringe a broadcast, different to the acts that infringe a Part 3 literary work, again, different to the Part 3 musical works. So you need to be sure what those acts are, and you need to be able to find them in the legislation. Most importantly, you need to be able to identify them in the facts. You'll need to know a little bit of authorization liability, as I said, but mainly I want you to focus on direct and indirect infringement. You will also need to know the defenses to copyright, the fair dealing defenses and the other limited royalty-free exceptions, and the basic outlines of the statutory licenses that exist that will excuse or limit the infringement action. And finally, you need to be able to identify the remedies that are available for copyright infringement. So there are 5 steps that I want you to take every time you come up against a copyright question. So the first one, subsistence. The questions we need to ask here are, first, is it a Part 3 or Part 4 subject matter? If it's Part 3, is the work original? Is it expressed in material form? Is it something which falls into the categories of literary, dramatic, musical, or artistic works? And does it have an Australian connection? 4 tests to determine whether or not copyright subsists. The 5th there that I didn't mention in that outline is, has it expired? And you'll have to look at the expiry term, which is different again between Part 3 and the different Part 4 works. For Part 4 works, we don't look at originality, but whether it is a sound recording, film, broadcast, or published edition that has an Australian connection. You need to then check whether any assignment has taken place or whether there's been a license that has been given. The next question is ownership. The default rule under Part 3 is that generally the first author of a work is the owner. Obviously, that's modifiable by contract. And the default rule under Part 4 is usually that the maker of the broadcast or the producer of the film or the maker of the sound recording and so on is going to be the first owner of copyright. Again, in practice, all of these are always modified by contract. Then you come to the tricky parts. After identifying all the works, you have to look at all the potential forms of infringement. And you need to go through the facts fairly carefully and make sure you don't miss potential actions of infringement. Because usually, in a particular subject matter, there'll be more than one copyright work. So, for example, if I copy a film, I might be making not only a reproduction of the Part 4 film, but the original screenplay, the musical works, the sound recordings that are embedded in the film, the dramatic works in the script, and so on and so on. So you need to be able to identify all the potential works and all of the infringements that might apply. And you'll only be able to do that through practice. Then we look at, has there been an actual infringement? Go through the infringement tests. Has there been a potential authorization infringement? So that is, if there has been a direct infringement, might it be possible that there is also someone else who is responsible for authorizing that infringement? And then finally, has there been some sort of dealing with infringing copies that constitutes indirect infringement? For example, importation or sale of infringing copies. Then we move to defenses. Check first all of the fair dealing defenses, then check the specific royalty-free exceptions, the private use exceptions, the computer software exceptions. There's a whole range of them. Incidentally, that's why the ALRC suggested we just consolidate all of those into a fair use exception, which would probably make our act a lot more simple, if not our job much more simple. But unfortunately for now, you still have to work through and identify all the potential defenses that might apply, or the exceptions that might apply to copyright infringement. Then you have to check the statutory licenses as well. Now, the statutory licenses are fantastically complicated. I'm not going to ask you to know them in a huge amount of detail, but you need to know that they exist. And finally, remedies. And the most important remedy in copyright is usually an injunction, as in other forms of IP, the ability to stop the person, to enjoin the person from infringing or continuing to infringe or attempting to infringe copyright. And then you get either damages or an account of profits at the election of the plaintiff, and there might be additional damages that apply under certain circumstances. You'll have to work through that, but it's not terribly complicated. There are also criminal offences, usually for commercial scale dealings, commercial scale infringements under the Act. And then finally, you also need to know moral rights. So look particularly for the moral right of attribution, the moral right of integrity. Has the way in which the copyright material has been dealt with, does that trigger a potential cause of action under the moral rights?